Are you a California landlord who'd like to evict a tenant to remodel that unit and get more money? Or maybe you're a renter who received a notice to vacate for renovation, or you've heard about this substantial remodel loophole? When can a renter be forced to move out for a substantial remodel? We are going to dive in and explain exactly what a substantial remodel is in the state of California for rental housing. And make sure you stick around to the end for the LA City substantial remodel flowchart where we break the steps down. Hey there, Christian Walsh, real estate agent with Wire Associates. We have been helping renters and landlords understand their rights so things don't go wrong. And remember, we can't give tax or legal advice, but for the most honest and up-to-date real estate advice, subscribe to this channel. The first important point is that a substantial remodel is a just cause, no fault reason to terminate a tenancy under AB 1482. And what's AB 1482? It is a statewide bill in California that governs just cause evictions and also governs rent increases. We've done longer content on that, and we encourage you to watch that. But we'll give you a quick overview of it right now so it makes more sense. So just cause evictions can be at fault or no fault. Whose fault? It is the tenant's fault. So at fault would be, for example, non-payment of rent. The no fault termination of tenancy, tenant hasn't done anything wrong. Landlord just wants to come in and take over the unit. AB 1482 governs those reasons. Substantial remodel is one of the reasons. Bear in mind that many houses and condos throughout the state are exempt from AB 1482 if the landlord's given the proper exemption notice, and landlords can terminate for no reason and don't owe relocation assistance. For many duplexes and larger, they are subject to AB 1482, and the landlord is going to have to give proper legal notice for one of the just cause, no fault reasons, like a substantial remodel, and they're going to owe relocation assistance to the tenant. And this relocation assistance at the statewide level is 1 month, and the landlord can choose to waive the last month's rent. While AB 1482 governs at the statewide level, if a local county or municipality has more strict regulations, then those will supersede AB 1482. And what this means is there may be special policies for termination of tenancy that are no fault just cause, special policies required for a substantial remodel. And we're going to cover LA City and show you the differences there. That is one example. They may also require additional relocation assistance. There's several areas where it could be 3 months rent or even more that's required for a no fault just cause termination of tenancy. So make sure as a renter or landlord you understand your local regulations. So what repairs or improvements or upgrades need to be done in order to qualify as a substantial remodel? We're going to turn to Civil Code 1946.2 for the exact definition. Let's dive into the Civil Code. I know most people's eyes glaze over when I pull this up, but it's important to see what actually the law says and not just an interpretation or reading an article on it. Let's actually see what it says. Let's go to the primary source. So here we are in California Civil Code. This is 1946.2, and this is what AB 1482, the Tenant Protection Act, modified when that legislation was passed. So what we're looking at is we got a breakdown on just cause, reasons to end a tenancy. So up at the top here we have at fault. So one of the major ones is default in payment of rent, etc. We're not talking about that right now. Right now we are talking about no fault just cause, and in particular we are talking about the substantially remodel the residential real property. So let's look at the actual definition that is in here in 1946.2. And we have a link below so you can go ahead and pull this up and read it. What it says: for the purposes of this subparagraph, substantially remodel, it actually defines it. It means the replacement or substantial modification of any structural, electrical, plumbing, or mechanical system that requires a permit from a governmental agency, or the abatement of hazardous materials, including lead-based paint, mold, or asbestos, in accordance with the applicable laws, federal, state, local, that cannot be accomplished in a safe manner with the tenant in place, requires the tenant to move out for at least 30 days. Cosmetic improvements alone, such as decorating, painting, minor repairs, other work that could be performed safely without the resident having to leave, those do not qualify as a substantial remodel. So that's important. So that's what the law says. It must be work that a tenant has to be out for a minimum of 30 days. So in a lot of cases, that's a lot of work. The other thing is you're going to have to pull permits. So it's going to be electrical, plumbing, or you need to be abating lead-based paint, mold, or asbestos. And it's got to be a lot of abatement in order to qualify. So there it is. It isn't a requirement for a dollar amount like 50% of the structure. There's no other requirements other than must be 30 days for the tenant to be out minimum. So that's major work. And you must have to pull permits for the work. So if those are met, then it qualifies as substantial remodel. Again, it specifically says it can't just be cosmetic. And what if a landlord decides to use a substantial remodel loophole just to get tenants out, doesn't do any work, puts it back on the market, or maybe does cosmetic work? Check out this next section. Well, this is an interesting letter from Community Legal Services in East Palo Alto. And what it talks about is landlords who have tried to do that. That is a fraudulent eviction that in some cases they've been ordered to pay big sums. So they talk about a recent case. They don't give a number, the case number or anything, but they say $50,000 paid to the tenant who were evicted fraudulently. In this letter, they go on to actually show you California Civil Code 1946.2, which we looked at. They show you what needs to happen in order to qualify. And there's some other important stuff. This letter is to request certain items on behalf of the tenant from the landlord to show that they're acting in good faith. Some of the things that they say that an attorney representing a tenant could ask for as discovery are specific information about the remodel, permits, architectural drawings, contractor bids or work plans, and invoices, work orders, receipts for purchases of fixtures or products to be used in a remodel or rental equipment, etc., to prove that a landlord is going to do a substantial remodel. And if this isn't presented, then it could be doubted that it's a substantial remodel and be considered a fraudulent eviction. So the substantial remodel loophole, a landlord really must be remodeling, and if not, they could potentially face stiff fines. So it's important that landlords and renters understand their rights under a substantial remodel. And don't forget, we're real estate agents based in Southern California. We have a regional sales and marketing center in Orange County and Los Angeles. You need to hire right so things don't go wrong. And I promise to share this with you if you stuck around to the end. Thank you for doing that. So I put this together. It's very basic, not fancy, but it's a flow chart for a substantial remodel. And specifically, this is for a tenant-occupied property in LA City under their just cause ordinance. So this is an example where a landlord must pull permits and has to get bids and do things ahead of time before they can actually deliver the notice to terminate tenancy. Not everywhere it's like that. Some landlords can just go ahead and deliver the notice and say they're going to do a substantial remodel. It is different in LA City, and this is applying to every property, every rental property in LA City is either under the RSO or JCO. We've done other content on that. I encourage you to watch that. So for the substantial remodel under the JCO, it is most common that landlords are going to sell their properties, and that's what we're using in this example. Substantial remodel. First, you meet with the contractor and you get a bid and you go through the scope of work, determine exactly what you're going to do with the property, and then you pull permits on what's going to be done, and you need to make sure that it's significant. It's enough for the tenant to be out for 30 days minimum, and it's systems like electrical, plumbing, new kitchens, new bathrooms, and abatement of maybe lead or mold or asbestos. Those are important things. Remember, 1946.2 says that. Pull those permits. Then the tenancy is terminated. Now the tenant can receive a 60-day notice to terminate tenancy. Landlord's going to deliver the 60-day notice to the city. The landlord's going to deliver the permits, and the landlord is going to fill out paperwork and pay fees to LA City. The other thing is the landlord's going to deliver a 60-day notice to the tenant, deliver the permits with that 60-day notice, and pay the relocation assistance. For LA City, the landlord has 15 days to give that money to the tenant. They can't waive the last month's rent, and they can't wait until they move out. So from there, if the tenant does not move out, it moves to unlawful detainer, and that's if the tenant doesn't move out after 60 days. And if the tenant does move out under that 60 days, then the remodel starts. Once the tenant's out, obviously that's when the work starts. Once the remodel is done, the landlord will sell for top dollar, or the landlord could move in, or the landlord could re-rent the unit. But in our scenario, most landlords are doing this to sell. And the advantage with this is they're able to have the property vacant of the tenant, and they're able to get top dollar because it's a turnkey property. We are pioneering this program in Los Angeles, and I understand it's difficult for Renters, they have to find another place, but we're going to make sure the law is followed. And what we're doing is we have brought all these pieces of the puzzle together. We have an attorney that helps with everything in the blue. So they're going to do all the paperwork to make sure it's done correctly, make sure that the renter's rights are respected. We have a contractor who does everything in orange, and that contractor actually, in the case of a sale, will pay for the remodel and will not be reimbursed until I sell the property on the open market. So we have this program set up. So if you're interested as a landlord, please reach out. And as a renter, if you're in LA City and you see that these steps aren't being followed, make sure you reach out to us as well, and we'll give you advice on where you can turn. And no need to raise your hand if you have a substantial remodel question. Just leave it in the comments below. Make sure you're subscribed to our free weekly email newsletter so you get updates like these sent to you every Sunday. If you like this video, we're just getting started. Make sure you check out this next one. Thanks for tuning in. This has been Christian Walsh, Forever Agent with Wire Associates and Berkshire Hathaway Home Services, and we want to hear from you.